we are looking at with the politics of knowledge production and politics of knowledge and knowledge production. We are trying to look at why you find that in many a time, for example, looking at our case in Zimbabwe, our government is very particular about people getting to know the truth. Why is that so? Why are they uncomfortable about the truth coming out? And why should they prescribe what should be known and what should not be known? Why should they prescribe the type of knowledge that should be produced for the national audience at large? Then we say that the right to know is also very vital in terms of knowledge and education, in the sense that the right to know gives us lessons. We learn from that which we know. When we get a record of what happened in the past, a truthful, proper record, we can draw lessons from it. What happened? How did it happen? Why did it happen? And from there, we can then draw lessons as to what to avoid and what to do so that we can actually have a harmonious future moving into the future. Then we looked at the importance of the right to know with regards to survivors and victims, wherein we say that as long as these people do not know what happened, they remain in limbo. There is no closure for them. For example, you don't know where your forefathers went to. You don't know where your mother went to. And looking at it from an Afrocentric perspective, those of us who are from a traditionalist perspective will agree with me. You cannot perform your traditional rituals if you don't know what happened to the person for whom you want to perform those rituals. Ukubuyisa, kurola guwa, you cannot do those without knowing the whereabouts of that person. So the right to know will actually assist you to get to know, to get to perform those rituals, and assist you in getting closure, which can actually be a healing instrument moving into the future. We also say that the right to know is actually something that is enshrined in our national constitution. Amendment number 20 of 2018, section 62, that actually talks about our access to information, meaning that if we know, we can only know if we get access to information. And in line with that, we actually looked at that as an issue that could actually even assist us when we look at what has been produced in the past but has been kept under wraps. We've got the Chiambagwe Commission, we've got the Dumbuchena Commission, even the Santora Commission was partially released. We don't know the truth about all those inquiries, so to speak. And currently we've got this Motlande Commission, and we wanted to know what happened, why it happened, who did what, and why they did whatever they did. Then we said, most importantly, when we are looking at the right to know, we should be able to speak freely once we know the truth, and remain free after speaking. In other words, the right to know is to be alive with the freedom to speak and the freedom after speaking. Then we say that we had a heated debate on issues of anyway, let me, before I look at that, we also say that the right to know is very important at 4 different levels. One, people to enjoy the right to know, the right to the truth at the individual level, at the family level, at the community level, and ultimately at the national level. People should know how things have occurred, how they have developed. And most important, we say that this right may be a meaningless right unless and until it is enjoyed within a specified reasonable time frame. You don't demand your right and remain demanding it without it being fulfilled. If you want to know the truth, we should know it within a specified time frame. That's what we are saying there, and I think that is basically what we came up with. But most importantly, we looked at the right to know as important for closure, for victims and survivors.
Thank you very much. The right to justice, please. 5 minutes.
Thank you very much. And, good evening, ladies and gentlemen, distinguished participants. Although I'm a politician, you can take it from me that it's actually now evening. You don't have to check your watches. I am actually correct. So our topic was the right to justice. And in our discussion, we felt that this was a very, very critical and important aspect to deal with the culture of impunity. Because the people know that they can get away with it, they can then repeat the same offenses, well in the knowledge that nothing will happen to them. So the first point, and not just society at large. When you look at atrocities, when you look at human rights violations, they don't just apply to the victim, but they also affect the society at large. So we felt that it was important that perpetrators or alleged perpetrators are brought to book. And we felt that this particular aspect of the right to justice would then result in effective remedies for the victims. Because when you know that someone who has been guilty or who has done something wrong are punished. And then we also looked at the issue of equality before the law. So under the right to justice, we felt that if you are going to have prosecutions, if you are going to have criminal trials, they must apply to all without fear or favor. So that you don't have a scenario where there is a selective application of the law, so that you don't have instances where some other people are not prosecuted, possibly because they happen to be politically correct. So that you have this administration of justice being applied to everyone. And then we also looked at the issue of the right to justice. We're not just looking at nitty-gritty justice, where you have aspects of punishment, but you must also look at the restorative nature of justice, as well as the redistributive nature of justice. So that at the end of the day, when we are dealing with this particular aspect, we are looking at it in that context. And for that to happen, under our discussion, we then looked at the issue of having independent and effective institutions which are responsible for the administration of justice. As you appreciate, the starting point is with the arrest. So you must have institutions like your police force and your other law enforcement agencies which are able to discharge their functions, not just impartially, but also very effectively. But when it comes to arrest, everyone is arrested if they are suspected of having committed offenses or having been guilty of either human rights violations or any atrocities. And then from, oh, sorry, all right. I'll try to speed up. Well, in my other life, I was used to charge by the hour. So, right. Then when you deal with the prosecution, you must also have independent and effective bodies which will then ensure that when matters are brought to them, they are effectively prosecuted. And then lastly, but most importantly, you then look at those who are going to adjudicate. You need to have courts which are able to perform and carry out their duties in a very impartial and effective manner. And then also look at the issue of administrative justice in terms of our processes and so on. And then we also came up with the idea that when you look at the traditional court system which we have, you find that it's generally cumbersome, it's time-consuming, and so on. So we felt that we must have provision for community justice systems, like what happened in Rwanda. They had their Gacaca systems, which can then deal with some of those matters at a local level. And we also looked at the international aspect. Obviously, depending on the nature of the crimes you are dealing with, there are some of those crimes which get to the level of genocide, crimes against humanity, and so on. So you then need to have that hybrid nature, so that in some instances, you can then have intervention or with the international flavor. Like if you look at the current Commission of Inquiry, we actually had a QC from the UK. We also had the former President of South Africa, Kgalema Motlanthe, chairing that commission. So you need to have that element of internationalizing it. And then we also talked about having a political will, the mindset, the commitment to actually do it. And then sometimes we have challenges where people are afraid because there's no protection. So the last point we dealt with is that we must have effective mechanisms for witness protection. But people are not hesitant. Those victims are confident that if they make their report, nothing will happen to them afterwards. My colleague there was talking of freedom after speech or whatever. So it's very critical that those witnesses, those victims are confident that if they make reports and so on, they are not subsequently victimized. Thank you.
Thank you very much. Guarantees of non-recurrence, please.
I'm representing the group on non-recurrence. Some of the points have been mentioned. Maybe I'll just, from my colleague, the Honorable, about access to justice. It's one of the issues we mentioned as something that will help us so that it does not occur again. First of all, people pointed out that. Oh, okay, sorry. Okay, people pointed out that the perpetrators of violence are still within the corridors of power, and therefore there is need to demilitarize and transform the security sector. I think this was one of the main points that was raised, that because our security sector is not yet demilitarized, or that our society is not properly demilitarized, what has happened is that a lot of structures that should not be secular, that should not be run by the military, are run by the military, but as well as it makes it difficult for the military to be accountable. And also there was a realization that from a historical point of view, our security sector has been involved or implicated in most of the violence that has recurred. And therefore the feeling was that maybe if we reduce their involvement in some of the sectors within society, it might help. Also, there was the point still to underline that fact that after independence, we did not transform the military sector, but just inherited the colonial military setup. And then there was a need for us to continue to analyze the structural systems that cause violence, and that this needs to be transformed as well, and need to identify foundations for peace. Also, there was the point about that we need to ensure that we work from the grassroots level, ensure that we involve people, we deal with our tradition and culture, and we allow the tradition and culture to speak into our future, but also involve it in finding solutions for peace and transforming some of the way we view things and do things. And also there was the issue of integrating Ubuntu, beginning to realize, rediscover our humanity, so that we will not segregate each other, we will not see other people as objects of violence, but we could look at each other as human beings. The use of the issue of social economic justice also came up as part of the issues that needs to be embedded or dealt with as foundational issues to ensure that there's no recurrence. Unemployment of young people is a major issue, and the general unemployment and lack of economic means for most people means that they are vulnerable in terms of committing violence. There was also the need to promote the role of traditional leaders as custodians of peace. The last part of what we did was a discussion around how do we ensure that we also encourage genuine leadership, people that are able to build the nation, embark on a national building process, and that will help us break from the past, but make each person to feel that they are part of Zimbabwe. And also there was the talk of how to build resilience. But also we talked about the issue of how do we begin to work on our history in such a way that the history will begin to teach us lessons that will not go back. How do we create memories? How do we begin to structure our history for our children and for the other generations that are coming, so that people will say, we'll never allow this to happen. So that was part of what we were saying. And also we talked about the need to have human security policies. In other words, policies that will protect the human security of persons in the nation. because the feeling was that the security sector was in fact designed to pursue human beings, to pursue each other, instead of looking at broader security issues for the nation, like water security, food security, etc. So therefore, as a result of that, we will have recurrence of violence, because if people are not secure in terms of food, in terms of livelihoods, in terms of there's climate change now, and there is a scramble for mineral resources. So all those things are major security threats that need to be to have a policy or a framework in which we could ensure that they do not breed violence in the future. Thank you.
Thank you very much. Last but not least, right to reparation, please.
I'm Rumpis Nyamba. I'm with CSU. So we started off the right to reparation discussion by defining what we thought it meant. And we were privileged to have Tony with us, who broke it down that there's 3 parts to reparations. We're talking about restitution, compensation, and rehabilitation. And we had a discussion about what those 3 mean. In restitution, we're talking about victims being restored to their original state as though time hadn't passed, as though nothing had happened to them. And in rehabilitation, we're talking about our medical or psychological treatment for victims. So we're looking at the case for Zimbabwe. And the first thing we said was, well, we need to analyze what we already have in place that could allow for compensation to take place. There was talk about a war victims compensation fund in in our history, which has come to an end, but was perhaps selective in how it compensated victims. We talked about that healing, access to healing is actually accessible across the country. We have many organizations that are doing medical and psychological healing for victims. And then we said, well, what about our policy and legal framework? And our group came up with the idea that we need a guiding policy, a guiding bill, a guiding act to do with reparations. And we had some examples from Kenya where this was actually worked into policy that guided the reparation process. So then we said, well, what scale are we talking about here? And there's been several studies that have been done in Matabeleland and across the country that Shari and Tony were talking about, which allude to the fact that there could be hundreds and thousands of victims if we were to take all of our episodes of violence into account. So what do we do about that number of victims? How do we monetize that kind of scale? And where is the political will to, to pay for that scale? So then we got examples of other types of reparations that have taken place. For instance, communal reparations. We had examples from Colombia that came up where communities or villages can come together and say that we are a traumatized community or we are a hurting community, and they can be community level kind of reparations. This made us think about the fact that perhaps the first step really should be that we should talk to victims and have this as a victim-centered approach. Before any work is done, to ask victims, what does justice look like for you? How do you conceive justice? How will you feel compensated? And then we said to ourselves, well, what instruments already exist to do this kind of research with victims and to start implementing the kind of justice that they're looking for? And we thought of the NPRC, for instance, already exists. Perhaps it should go out. Well, when it goes out, one of the questions it should be asking people as they're taking statements is, what does justice look like for you? How will you feel compensated? How will your community feel compensated? And there was also talk about some low-hanging fruit that already exists. Pre any research, we already know issues of documentation, for instance, in Matabeleland, with the Gukrawundi atrocities, that people need documentation in order for for them to access identification and all of that. So how do we, even before the work of the research is done, make it easier, is it passing it through Parliament, that people can already start to access some of these forms of reparation and compensation to get their lives and their dignity back. Yeah.
Thank you very much. Thank you for being within the time. Another round of applause to all of our presenters and yourselves. Thank you very much to our presenters and to the groups for very concrete recommendations. I think it will be interesting to see how we can take this forward in tomorrow's thematic group discussions as well. And borrowing slightly from your presentations, I'm going to ask my next panel to come up, Jackson and Otto, building on what has been presented from the different groups today. they will see how critically reflect on the framework of Zimbabwe's TJ process. So I ask that Jackson and Otto please come join me up here, or just Otto, I believe. Okay. No, that's fine. Colleagues, it's nearly 20 to 6. Otto says 5 minutes. I'm going to add another 10 just in case, and then we will wrap up for the day. Thank you.
Thanks, Elizabeth. It's difficult to speak.